Ladies and gentlemen, a very good morning to you all. It's a real pleasure, first of all, to open this symposium on trade secrets and innovation, and secondly, to welcome you all here, to extend an extremely warm welcome to you all here, and to thank you all for your participation, all of the participants and all of our speakers, to thank our speakers in particular for the time that they are devoting to this. We are delighted to be hosting this conference on trade secrets, in particular, which I would suggest has been internationally a somewhat neglected subject, despite its importance and I would suggest also increasing importance. But if we look at the international picture, of course, well, as I think you're all aware, there are provisions in the Paris Convention which were inserted in the Act of Washington in 1911 on protection against unfair competition. But those provisions, if you look at them in the Paris Convention, and the examples that they give of unfair competition are more directed to the marketing side, I would say, and branding and indications of source and so forth. There is then, of course, Article 39 of the TRIPS Agreement, which is now almost 25 years old, and which expresses itself to be an example of Article 10 bis of the Paris Convention. But despite these provisions, I think the subject matter has been largely neglected at the international level. And perhaps that neglect is a consequence of not the relative unimportance of the subject matter, but of the diversity of approaches, the legal approaches that we've found in the world for the protection of trade secrets or confidential information. In general, as you know, the common law countries have adopted a different legal approach to the civil law countries. So in the Anglo-American common law tradition, there has tended to be, as a generalization, a comprehensive approach, although even within those two traditions there have been divergences, since the American approach makes a distinction between commercial trade secrets and the action of privacy on the other hand, whereas the English approach rather, tends to have a comprehensive approach covering not only commercial but also personal and professional confidences in the same legal action. In the civil law countries, of course, there have been provisions traditionally in the civil code, and there have been criminal provisions in relation to professional confidences in the criminal code generally. Now, in recent years, I think we have seen signs of change, both in policy activism in relation to trade secrets, and also to some extent in convergence of these two very diverse approaches that we've traditionally seen across more than 100 years. I think we see that enterprises and indeed governments are according more policy importance to trade secret protection. In recent, using that in a general sense, years, we've seen that the European Commission, Japan, China, the United States of America, and many other jurisdictions have all been active in enacting forms of trade secret legislation. And there is more convergence in those approaches than there has been traditionally. So what lies behind this increased attention, I'd say, that is given to trade secrets? And I'd suggest here we have perhaps 3 or 4 important reasons. The first, I think, is that trade secret protection, of course, protects certain classes of information, confidential information, from misuse or misappropriation. And digitization has transformed everything into data. And once data is shared or communicated, it becomes information. So there is increasing, as we know, value in data, even if it's sometimes hard to find. Data are a fundamental business and scientific asset. So a legal remedy that addresses the misuse or misappropriation of data or information naturally, I think, in the digital age and the digital economy assumes much more importance and significance. Secondly, I think that trade secret protection play, as we know, a very fundamental role in any collaborative business relationship, whether it's the relationship of employer or employee, contractor or subcontractor, university research with an outside enterprise, global value chains that we see. They all depend upon the sharing of information and, depending on the relationship, the sharing of extremely important and confidential information. So this, I think, is another reason why we're seeing increased attention to the subject matter. A third reason, perhaps, is the mobility of skilled personnel. So as a consequence, again, to some extent, of globalization and changing business models and global value chains, we have seen much greater mobility, perhaps, in skilled personnel. And so enterprises, I think, tend to pay more attention to the distinction between what is their proprietary, as it were, information on the one hand and what is general business information that might be shared by any particular employee. And then finally, I think, with the digital economy and with information and communication technologies, of course, the principal means of the storage and the communication of information is now digital and based on information and communications technologies. And that has led to a new form of vulnerability for information and data, which we see in various pernicious forms of commercial activity, whether it's cyber intrusions or hacking or espionage. And so I think the vulnerability, the additional vulnerability created by ICTs have also emphasized the importance of this particular legal action. Those being the reasons now for the importance or the commercial significance of the protection of trade secrets, I think there's also a fundamental policy question that we need to at least touch on, which is, well, why protect them at all? Aren't you protecting secrecy here? And don't we have, in much of intellectual property policy, a policy of transparency, of getting information out into the public domain eventually? And I think the answer to that is that, first of all, the viability of so many commercial relationships depends upon the protection of information and the confidence that business enterprises might have in their capacity to protect information. And I think it's really paradoxical that actually the protection of secrecy enables sharing. If you don't have confidential information protected, you're not going to share it if you don't have that confidence and that security. So I think this is the primary reason, and you can compare it to so many social relationships that depend upon confidentiality being respected, whether it's doctor-patient, or lawyer and client. There are so many that depend upon this, and it's similar, of course, in the commercial sphere. There is, and this goes to the theme of the conference, of course, through protection of commercial information and incentive also provided to the generation of useful information. And so much information cannot be captured of value commercially and scientifically, cannot be captured by the patent system because, for example, it deals with experience with the use of a patented invention, post-patenting information, because it deals with business information, entirely business information. It's of relatively little importance to know what process another enterprise is using unless you know the business results that are being obtained from the use of that process. So there is a wide range of reasons for generating useful information that are incentivized by the protection of trade secrets. And then I think finally, a policy basis is that, of course, it's a fair basis for competition. Can you imagine competition with no respect for the confidential information or trade secrets of particular enterprises that are there to be plundered by any business within the context of any business relationship or through intrusions of various sorts? So I think it's a very important subject matter. It's a subject matter that is attracting more and more attention. Perhaps it is time for us to pay much more attention to this internationally, and so we welcome, in particular, this symposium in light of all the recent developments in connection with trade secret protection. Where do we go to from here? Well, we're at an extremely preliminary stage. We are simply having a discussion in this conference. However, because of all the developments to which I have referred, I think we should have at the back of our mind the possibility of developing discussions at the international level so as to explore the possibility of coming out with some principles that might be shared internationally in an approach to trade secret protection. I would like to just note finally that many or most trade secret disputes are more about facts than law. Very often the law is not really in question. There is an agreement about the law, but there is a disagreement about the facts and who did what and when and how. In this regard, I would like to mention that we are starting at WIPO next year, probably in the month of March next year, a digital timestamping service. And digital timestamping services, as you know, are of particular value in having an evidentiary proof of the existence of data or certain classes of data at a certain period of time deposited by a certain person. And that we spoke about last week. We had a forum. We had judges from about 160 countries present last week for an intellectual property forum on intellectual property and the judiciary. And they were very much welcomed this move. We spoke about it in the context of the sorts of evidence that might be coming or that are coming before them as judges in the course of litigation. So we're calling the service WIPO Proof, and we'll, of course, provide you much more information in the course of time.